A federal judge has just delivered a major blow to one of the Trump administration's most sweeping immigration policies, ruling that the pause on green card approvals for people from 75 countries is unlawful. This decision touches family members waiting years to reunite, workers and investors who have been stuck in limbo since the start of this year. Today we are breaking down exactly what the judge said, who this affects, and what happens next. If you are interested in this topic and liking this video, please stay tuned until end of the video. If you are liking this video, please hit the bell button, subscribe and like it so that you may get updates straight to your smartphone. Now let's get into the video. Let's take a closer look at how we got here. Back in January of 2026, the State Department quietly rolled out a policy directing consular officers around the world to stop approving immigrant visas for applicants from 75 specific countries. The stated reason was concern that people from these countries might become what immigration law calls a public charge, meaning someone who depends heavily on government assistance. Officials said they needed time to develop additional screening procedures before letting these cases move forward. In practical terms, this meant that green card applications simply stopped moving. No approvals, no denials, just an indefinite freeze. According to sources, the countries affected included nations like Nigeria, Colombia, Russia, and Egypt, among many others. The freeze hit family-based applicants the hardest, but it also reached some employment-based and investment-based cases, including EB-5 investor visa applicants. For thousands of families, this meant husbands separated from wives, parents waiting to bring over children, and investors with money already committed to the United States economy, all stuck waiting with no clear timeline. Here's what you need to know about the legal challenge that just changed everything. The case is called De Moura Gomez versus Rubio, filed in the United States District Court for the District of Columbia. U.S. District Judge Amit Mehta reviewed the policy and, in an opinion issued on July 31st, found that the Secretary of State had exceeded his legal authority under the Immigration and Nationality Act. What makes this case different is the reasoning behind it. Judge Mehta pointed out that under federal law, it is consular officers, not the Secretary of State, who are given the responsibility to evaluate each visa application individually and decide whether that specific applicant is likely to become a public charge. By issuing a blanket pause covering 75 countries, the policy essentially predetermined the outcome for every applicant before any individual review even happened. Immigration attorneys following the case say this distinction matters enormously. The plaintiff's legal counsel, a partner at a Florida-based immigration law firm, argued that the policy was fundamentally unfair because it required individualized review on paper while dictating a blanket refusal in practice. In other words, Congress gave consular officers the power to make case-by-case decisions, and this policy stripped that power away entirely, replacing it with a one-size-fits-all denial for entire nations. So who exactly is affected by this ruling? The following categories are worth understanding clearly. First, there are family-based immigrant visa applicants, meaning spouses, children, parents, and siblings of U.S. citizens and green card holders from the 75 listed countries, filed under categories like CR1, IR1, and F2A. Second, there are employment-based applicants, including some EB series green card seekers whose job offers or petitions were already approved, but whose final visa interviews or approvals were frozen. Third, there are EB-5 investor visa applicants, people who invested significant capital into U.S. businesses specifically to qualify for a green card, only to find their applications stuck indefinitely regardless of how strong their case was. However, before jumping to conclusions, it's important to understand exactly what this ruling does and does not do. The court ordered the State Department to move forward and adjudicate the individual plaintiff's EB-5 application. But the injunction, at least for now, applies specifically to that one plaintiff. It does not automatically lift the freeze for every single applicant caught up in the 75-country pause. Despite this narrow scope, Immigration experts note that the court's broader conclusion, that the underlying policy itself is unlawful, gives significant ammunition to the other lawsuits currently making their way through courts in New York and Washington, D.C. Legal analysts suggest that this ruling could become a key precedent those other judges lean on when deciding similar cases. Beyond this specific ruling, the administration has continued pushing forward on related fronts. The Department of Homeland Security recently tightened its own public charge policies through final regulations issued just last month. This suggests that even as courts strike down individual pieces of this broader strategy, the administration is not backing away from its overall approach to public charge screening. A State Department spokesperson responded to the ruling by saying the agency generally does not comment on ongoing litigation, but added that the administration remains committed to upholding rigorous screening and vetting standards for all visa applicants. What does this mean for the thousands of families and applicants still waiting? In practical terms, if your case falls under the 75-country pause and you are not the specific plaintiff in this lawsuit, your application status likely has not changed yet. However, this ruling strengthens the legal argument that your case should not remain frozen indefinitely without individual review. Immigration attorneys are advising affected applicants to stay in close contact with legal counsel, monitor developments in the New York and D.C. lawsuits, and be prepared for potential class-wide relief if additional judges rule the same way Judge Mehta did. As someone with a pending green card application from one of these 75 countries, this situation might feel incredibly frustrating. You have followed every rule, submitted every document, and now you are watching your case sit untouched because of a policy a federal judge has already called unlawful. That frustration is completely understandable. At the same time, this ruling represents real legal momentum. Courts have now recognized, at least in this case, that blanket nationality-based freezes conflict with what Congress actually wrote into immigration law. Advocacy groups warn that even with favorable rulings like this one, real-world processing can lag behind court decisions by weeks or even months as agencies work out how to implement changes. So while this is genuinely good news, patience and continued legal advocacy remain essential. Now let's clear up a few common misunderstandings we have seen in the comments section of similar videos. The biggest misconception is that this ruling automatically reopens every frozen green card case from all 75 countries right now. That is not accurate. As we explained, the order currently covers one plaintiff's case, and broader relief depends on how the New York and D.C. lawsuits are decided in the coming months. The biggest question viewers tend to ask is whether being from one of these 75 countries means an automatic denial. It does not. This policy was never a formal ban written into a public list of denials. It was a processing freeze, meaning your case was paused, not rejected. Immigration experts note that a paused case and a denied case are legally very different things, and this ruling reinforces that consular officers still owe every applicant an individualized decision. Finally, the biggest concern we hear is around timing, specifically how long affected applicants might now have to wait even after a favorable ruling. Legal analysts suggest that timelines will likely vary significantly depending on which court, which category, and which consulate is handling a given case, so there is no single universal answer yet. To summarize, a federal judge has ruled that the 75-country immigrant visa pause violates federal immigration law because it strips consular officers of their legally assigned authority to review cases individually. While the immediate order applies to one plaintiff's EB-5 case, it opens the door for broader relief through ongoing lawsuits in New York and D.C. If you or your family members are impacted by this policy, staying informed and connected with qualified legal counsel is more important now than ever. The path forward may still involve challenges, but there are real practical reasons for cautious optimism. That's all we have for this bulletin. The Immigration Update channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. Thank you for visiting us today, and we'll see you in the next video. If you haven't subscribed to our channel, please subscribe to the channel for more U.S. immigration update videos.